In the corridors of American power, where centuries-old traditions meet the disruptive force of modern politics, a silent standoff is unfolding. As President Donald Trump prepares for his first address to Congress in his second term, an unmistakable tension lingers. With each step past the bench, the justices embody the weight of history and law, inviting us to consider, how does the judiciary preserve its authority when challenged by bold executive actions? A court under pressure. Recent weeks have seen a surge of legal challenges sparked by Trump's executive orders, placing critical cases squarely on the Supreme Court's docket. Traditionally cautious about wading into overt political disputes, the court now faces cases that test the limits of its long-standing norms. At a Princeton alumni event, Justice Elena Kagan remarked, "A lot of people are focused on the courts generally, on my court in particular." Her candid observation reflects not only the heightened public scrutiny, but also the immense responsibility the justices shoulder as they navigate these turbulent legal waters. On the other side, Trump has maintained his stance on executive authority. In a recent social media post, he declared, "He who saves his country does not violate any law." This statement, delivered with characteristic boldness, challenges traditional interpretations of the separation of powers, sets the stage for a critical judicial review, a delicate balance. Supreme Court's long-held practice of avoiding direct political confrontation is now under a subtle yet significant strain. Many justices opt out of attending presidential addresses, custom dating back decades, while Chief Justice John Roberts has traditionally made appearances that signal the court's commitment to its role. Should Roberts attend this session, the meeting between the president and the bench may carry a palpable, albeit measured, tension. In 2018, Roberts reaffirmed the court's independence by stating, "We do not have Obama judges, or Trump judges, Bush judges, or Clinton judges." Despite past decisions that have swung both ways on Trump-related issues, the new legal challenges suggest that the judiciary may soon need to reaffirm its boundaries. A current case involves Trump's decision to freeze $2 billion in foreign aid, despite a lower court ruling for its release. Plaintiffs argue that the administration has taken no steps to comply with the court's order, a charge that the Justice Department contests by emphasizing its constitutional duty. Acting Solicitor General Sarah Harris stated, "The administration takes seriously its constitutional duty to comply, legal precedents, and the road ahead." Adding historical depth to the unfolding drama, Justice Brett Kavanaugh recently invoked the 1974 Supreme Court decision that compelled President Nixon to turn over the Watergate tapes. His reference underscores the court's enduring commitment to legal precedents, regardless of the political climate. Justice Sonia Sotomayor reinforced this perspective by stating, "Court decisions stand. Whether one particular person chooses to abide by them or not, it doesn't change the foundation that it's still a court order." Her words serve as a reminder of the binding nature of judicial rulings, even as the executive branch tests their limits. As the court braces for a series of pivotal rulings, its future actions may shape the balance of power for years to come. The coming decisions will not only resolve current disputes, but could also redefine the contours of executive and judicial interactions in a modern democracy. For now, as the justices prepare to greet the president with customary formality, the nation watches a quiet yet profound dialogue on the rule of law, a dialogue that promises to influence the very foundations of American governance.